Hello everyone. We all know that the Constitution of India guarantees fundamental rights to every citizen, freedom of speech, right to equality, right to protest. But does a soldier standing on the Siachen glacier at minus 50 degrees Celsius have the same right to go on a strike or speak against the government as a civilian? The answer is a complex no. In India, the very people who protect our freedoms often have to surrender some of their own. Today, we are breaking down Article 33 and Article 34 of the Constitution, the legal framework that balances national security with individual liberties. If you are preparing for UPSC law exams or just curious about how the armed forces work, this video is for you. Let's dive in. First, context. Part 3 of the Constitution, Article 12 to 35, provides fundamental rights. They are mostly against the arbitrary actions of the state. However, Article 33 is a unique provision. It gives the Parliament, not the state legislatures, the power to restrict or abrogate, completely remove the fundamental rights of certain specific groups. Who does this apply to? Members of armed forces, Army, Navy, Air Force. Members of paramilitary forces, BSF, CRPF, CISF, etc. Police forces, intelligence agencies, RAW, IB. Non-combatant staff, cooks, barbers, carpenters. Why? The core reason is to ensure the proper discharge of duties and the maintenance of discipline. Article 33 Restriction Mechanism. Under Article 33, Parliament has passed several laws including the Army Act 1950, the Navy Act and the Air Force Act. What rights are restricted? Freedom of speech and expression Article 19. Soldiers cannot give media interviews, publish books, or write articles without permission, especially regarding national security. Freedom of Assembly Association Article 19. They cannot form unions, associations, or participate in political activities. Right to legal remedy Article 32. In many cases, court martial decisions cannot be challenged in the Supreme Court or High Court. Essentially, a soldier sacrifices his individual rights to protect the collective rights of the nation. This is a voluntary professional trade off. Martial law. While Article 33 deals with the people in forces, Article 34 deals with the situation, the imposition of martial law. When martial law is in force in any area of India, the ordinary legal courts are suspended and the military administration takes over. Article 34 provides that Parliament can indemnify, protect any member of the armed forces for actions taken during this period. It protects soldiers from legal suits for maintaining or restoring order. AFSPA and the debate. Now let's talk about the most controversial aspect of SPA, Armed Forces Special Powers Act. AFSPA gives special powers to the army in disturbed areas to maintain public order. It allows shooting to kill on suspicion. It provides immunity from prosecution. Critics argue this violates Article 21 right to life and is a mockery of human rights. However, the supporters and the Supreme Court Naga People's Movement of Human Rights case have held that this is a national necessity to combat insurgency. Where do we draw the line? While national security is paramount, The judiciary often emphasizes that the armed forces cannot be a rights free zone. The restriction must be reasonable and necessary. To wrap up, Article 33 and 34 are not about taking away rights, but about guaranteeing that the forces can do their job without conflict of interest. It is a necessary constitutional sacrifice. Article 33. Parliament can restrict fundamental rights of armed forces and police forces. Article 34. Restriction during martial law. What are your thoughts on AFSPA? Should there be more accountability? Let me know in the comments below. If you found this legal analysis helpful, hit that like button, share it with your friends, and subscribe for more deep dives into the Indian Constitution. Thank you. Bye.